case here. Our final case for this morning is Sandra Sheridan versus State of Florida Department of Health. Counsel, are you ready?
I sure am.
Okay, please get to it.
All right. I think I'll split it 10 and 5, although I don't think I'm going to need all that.
Okay, great.
Good morning, Your Honors. My name is Jim Garrity. I'm here on behalf of the appellant, Sandra Sheridan. She, of course, lost on summary judgment at the trial court level. We're asking the court to reverse that. This case was a civil rights case at the trial court level. The hearing on summary judgment revolved all around the administrative exhaustion requirements for civil rights claims. There are some very technical principles that deal with the administrative exhaustion concept, and that's reflected in some of the disagreements and what the cases say and what they require. But I think that all of the arguments here and all of the principles that we're asking to reverse this case on can be sort of summarized into 5 basic rules about the exhaustion requirement, all of which we say the trial court violated here. Rule number 1 is that the law regarding administrative exhaustion is quite clear that we don't require aggrieved civil rights victims to do the job of the agencies that are charged with completing that administrative review process. We don't require the victims to do their jobs. Rule number 2, we don't punish aggrieved victims of civil rights issues if the agencies haven't done their job. We don't do that. Rule number 3, quite clear, whether it's a state or a federal civil rights statute, we interpret the statutes in favor of finding a remedy, in favor of allowing the cases to proceed on the merits, and not be tossed out on hyper-technical grounds. Rule number 4, we don't use knowledge gained in hindsight and then imbue that to the aggrieved victim and say that based on that information, which we know now, but we didn't know then, that the victim should have done something differently back at the time.
Let me ask you a factual question, a representation made in the brief. I think it was your position that it was the plaintiff here was unable to comply with the 90-day right to sue timeline and also the 180-day investigatory period for FCHR. Why was that, since the 90-day right to sue timeline was limited to the federal law claims as opposed to the state claim, which she ultimately filed the lawsuit on?
Sure, great question. I know that there are schools of thought that right to sue letter only applied to the federal claims and that something else later on might be done with the state law claims. I've been doing civil rights work for 30 years. I don't know, quite frankly, one, that I agree that the right to sue letter in a work share agreement state where one or the other, you know, it's like the post office. If I drop my mail off at Centerville or downtown, it's all received by the post office. The same rule applies in Florida. There's a work share agreement that says that you drop it off at the FCHR, you've dropped it off in Miami at the EEOC, and vice versa.
If you check the right boxes.
If you check the right boxes.
And the boxes were all checked.
You bet, if you duly file. So in this case, we dual filed. We say that we, in fact, as a factual matter, filed with the EEOC and we filed with the FCHR. We did that because this is a work share agreement. Now, it's not every case where the EEOC issues a right to sue letter and then the FCHR separately at some point down the road issues its own finalization documentation. That doesn't always happen. I can tell you what we do is when we get that right to sue letter, in my view, that's the clearance from the control tower to take off. That's what we get in these cases, whether it's issued by the FCHR or the EEOC. And as I say, they don't typically each issue one in every case, otherwise there'd be no reason for the work share agreement. They'd each be duplicating their labor every time.
Right. Well, it is interesting that the right to sue letter itself in bold print says it's, you know, limited to the federal lawsuit and there may be other time limits for filing suits under state law. I mean, whether that's right or wrong is a matter of law. That's what the letter says.
It does say that, and I tell you right now, I would never wait any period of time beyond the 90 days. Once I get a right to sue letter from either one of those agencies, we're going to file. And you know, I can tell you from background that there's a huge body of law around whether you filed in time. And you know, you have 90 days from the issuance of the right to sue letter. Of course, if the EEOC mails it out of Miami, we're not going to get it that same day. So courts say, well, there's a 3-day grace mailing rule, even though it says you shall file within 90. The law on that is also very complicated. I'm not sure as I stand here that I would agree that the EEOC's issuance of a right to sue letter in a work share state like Florida, and I also practice in Georgia, they don't have a state agency, we don't have that problem there, but in a work share agreement state, the agreement says, and it's in the record, that the act of one is the act of the other, so we can't take that chance. The other thing I want to stress is that, like I said, it's the right to sue letter is what we get. In this case, we didn't know, and they didn't know, that when the EEOC issued that right to sue letter right away, that they hadn't picked up the phone and called the FCHR and said, hey, we're thinking about doing this, or it's untimely, do you guys want it? No, we don't. We don't know what they said. We wouldn't know. The document that we get is the right to sue letter. We don't get any notification behind the scenes within the agencies as to what kind of communications they'd engaged in. And I respectfully submit that it wasn't until this lawsuit was filed that both parties learned that the FCHR had not had, or at least it says it hadn't had any contact with the EEOC. That's not something we would know. We did everything that was asked of us and nothing that wasn't. We timely filed the charge. We dual filed it. We didn't get in the way of either agency. We didn't, like a lot of the cases they cite, we didn't go to the Florida Commission, which some lawyers will do, and say, give me that right to sue letter, I need it right now. I think that's a fatal flaw in many cases. We didn't do that. We didn't ask them to do anything. So we timely file it. We stay out of their way. We got the right to sue. We timely file. What's troubling about this case is a couple of things. One is that the case law, I think, uniformly says you don't punish the aggrieved victim for flaws by the agency. And we've cited some cases from this court. There was one between the FDOT and the FCHR. We cited a U.S. Supreme Court case, FedEx versus Holowecki. Lots and lots of cases that say you don't punish the aggrieved victim for flaws in the agency's process. Clearly, this was just a mistake that happened behind the scenes between the Florida Commission and the EEOC, over which we had no control and regarding which we had no role.
Well, let me get to, I think, another difficult legal issue, and that is, let's just assume the complaint was prematurely filed because it was filed before the 180 days that FCHR has to investigate. Then the question becomes, is the jurisdictional one. Did FCHR lose jurisdiction? I will confess, I thought the 11th Circuit opinion by Judge Dabena was very persuasive in that regard, and that it's not jurisdictional, and that the court can simply dismiss it, let FCHR do its business, and then it can become ripe, so to speak. But there's other cases that are in conflict with that, the third DCA Sweeney decision. So help persuade the panel, the court, that the 11th Circuit should be followed as opposed to the 3rd District.
Yeah, two arguments on that, and thank you for the question. One is, when I look at everything relating to civil rights claims in Florida or Georgia, I ask myself, what is the overarching purpose of these statutes, and what's the goal, and what has the Florida Supreme Court said is the goal? And it has said consistently, find the remedy if you can. So I start with that kind of mantra, and there's no dispute about that. They say we don't want these cases being bounced on hyper-technical grounds. And again, the case in front of you is one where we did nothing to create this situation. So on to the 11th Circuit's question. Yeah, I think there's plenty of cases that follow the 11th Circuit. They say this isn't and shouldn't be jurisdictional. There are lots of remedies. In the event you even have a defendant that says it suffered prejudice, I don't think you have that here. There's no demonstration of prejudice. This case sat largely idle for long periods of time. But the courts have said, I think the better reasoning is it's not jurisdictional, and courts have done a couple of things. One, they've dismissed the case and say, go back, fix it if you can, or two, abate it. And that's a common approach that a lot of trial courts will take in a variety of circumstances, not just civil rights, where there's been something that's maybe prematurely filed.
But if the trial court abates it and it goes to FCHR and they find no cause, where the only kind of review is through an administrative hearing, doesn't that kind of circumvent the FCHR process model of review?
So if they issue a no-cause finding within 180, because I think that's the only circumstance where we would have to go the DOA process.
Right, you're saying because after 180, it's assumed because you can sue. But yeah, so let's just say it was the complaint was prematurely filed. The court abates it, but then FCHR within the 180 days says this is without merit and no cause, and really then the appropriate remedy is through the administrative process and not through circuit courts. How do you reconcile that?
And I might be talking a little bit off the top of my head here, so take my next answer with a grain of salt. I don't know. Obviously, if the court dismissed it and said go back to the FCHR, then we don't have to worry. We can go to the DOA, I guess, after the FCHR issues the no cause finding. If the court just debates it and doesn't dismiss, then in theory the court could then dismiss it and force us to go. If the lawsuit's not going forward, I don't know that there's any prejudice to the defendant. I don't know that I would agree that this case was prematurely filed because, again, we know now, but we didn't know, and the department didn't know back when we filed this, that there had apparently been a ball dropped between EEOC and FCHR. And I suggest if you affirmed, it would be contrary to the rule that says you don't hold plaintiffs, aggrieved civil rights plaintiffs, who've done nothing wrong on their own to facilitate this error, the ball dropping. Don't hold them accountable for the problem behind the scenes.
But FCHR is still entitled to its 180-day investigative period and conciliatory, opportunity. So if the lawsuit was filed before 180 days, regardless of whose fault it is, isn't the system, require that process, be fulfilled?
We think it should. That's the reason for the system, although two things here. One is that we didn't know what was going on behind the scenes. We didn't know that the EEOC hadn't contacted. And two, we do have, for whatever weight you want to give it, we have testimony from the highest official at the FCHR that they would have done nothing here and that they do nothing. It reminds me of what I do on Halloween night. I turn my lights out and I hide behind the curtains and wait till everybody goes away. That's what the FCHR says it would have done to us. The executive director says we wouldn't take their charge, we wouldn't investigate, we wouldn't do anything. Once the EEOC dismissed, we're done with this thing. Now, whether that's consistent with their obligations under the law or not, it's an argument for another day, but they did say we would not have done anything here. So if nothing else, you have a record on which we can safely say there's no harm and no foul here, because even the administrative agency that they hypothetically say suffered here says, no, we didn't. We wouldn't have done a thing. We wouldn't answer the phone. We wouldn't open the doors. We wouldn't turn the lights on. We would do nothing. So we're kind of right where we are if the process had worked its way out in some other path, because the Florida Commission wouldn't have done anything. And quite frankly, I don't even know. There's no way to know. There's nothing in the record. Maybe somebody from the EEOC in Miami called the FCHR and said, we're about to bounce this thing. Do you want it? And they say no. I don't know. I don't know what happened behind the scenes, but what I do know is we got the piece of paper that we're supposed to get. We did everything we are supposed to do. And when we get that right to sue, like I said, that's the control tower saying it's time to take off. That's all we can do here or in any other case. And what the department would have us do is, apparently, pick up the phone and call somebody at the FCHR and say, hey, did you get the file? Is it okay if we do something here? Did you guys communicate? We didn't do that because the courts have said consistently, we're not charged with mistakes made by them, and we're not charged with responsibility to do their job. And that's our case in a nutshell. I appreciate your time. Thank you for the questions.
May it please the court. Brian Hayden on behalf of the appellee, the Florida Department of Health. We're here today, Your Honors, on the review of a final order entering judgment in the department's favor on the department's motion for summary judgment. Now, the underlying lawsuit in this case involved a single claim for race discrimination brought under the Florida Civil Rights Act. The department respectfully requests that this court affirm the lower court's decision in all respects. Put simply, Your Honor, this case is about a complainant who filed a lawsuit before exhausting her administrative remedies and who now wants this court to change the law to fix a fatal defect that can't be cured because she waited to the last minute to file her charge of discrimination. Now, essentially, what appellant wants this court to do is to make a substantive change to the Florida Civil Rights Act, which would have the effect of allowing complainants to purposely circumvent the administrative requirements of the Florida Civil Rights Act. Your Honors, time permitting, I'd like to go over 3 reasons why the lower court's decision should be affirmed. First of all, the EEOC notice of right to sue, as Judge Ray, you've pointed out, does not apply in this case because there are no federal claims at issue. Secondly, the appellant has abandoned or failed to preserve for appeal the argument that the Premature filing of her complaint did not divest the FCHR of jurisdiction. And thirdly, even if this court were to consider all of appellant's arguments, whether or not they've been abandoned or not preserved for appeal, it's still the case that appellant has not exhausted her administrative remedies. One other thing, Your Honor, before I go on to those points, I would like to point out, I think it's important that the appellant in this case was not pro se. She was represented throughout the administrative process by very experienced and knowledgeable employment law counsel. Now, as to the reasons why the lower court's decision should be affirmed, the first one is that the EEOC notice of right to sue doesn't apply in this case. The controlling law on this point is Woodham versus Blue Cross Blue Shield. The Florida Supreme Court decision stands clearly for the proposition that an EEOC notice of right to sue does not meet the administrative requirements of the Florida Civil Rights Act. Title VII and the Florida Civil Rights Act are two separate statutory schemes, and so the federal procedural requirements that apply to a claim brought under federal law don't apply to a claim brought under the Florida Civil Rights Act. So the federal procedural requirement that appellant is relying on is not receiving a right to sue notice and then saying, oh, I had to file my lawsuit within 90 days or be forever barred. That simply doesn't apply because there are no federal claims here. The initial brief makes several statements that I'd just like to point out that are simply untrue. First of all, the appellant says that she was bound to file a suit within 90 days or be forever barred. That's an untrue statement.
Well, that's a legal conclusion, and so can we move past that? Because I think the more, as I pointed out earlier, I think the more difficult issue is whether, assuming the complaint was prematurely filed because it was filed before 180 days, is that a jurisdictional defect or not? And I see a conflict in the case law on this point. I particularly find the 11th Circuit opinion persuasive, but I know there's contrary opinion, and so help me understand why the 3rd District's Court of Appeal decision in Sweeney is the more appropriate one.
Certainly, Your Honor. As you've noted, the Sweeney Court's decision, 3rd DCA, issued in 1998, they held that the mere filing of a complaint divests the FCHR of jurisdiction and prevents the accrual of the claim. And they held that based on, I would submit, a plain reading of 760.11 subsection 5, which basically refers to such action. And such action, I would submit, is the filing of an action under the Florida Civil Rights Act. That plain reading of the statute, I believe the 3rd DCA, the 3-panel decision in Sweeney got that correct. Another reason why I think their interpretation of subsection 5, the Sweeney Court's interpretation of subsection 5, should control is because the liberal interpretation that appellants would want this court to adopt would allow for a gaming of the system. And this is what I mean by that. If this court were to adopt the liberal interpretation that they're putting forward, a complainant could have a claim under the FCRA, knowingly file it outside the EEOC's 300-day window, knowing that the EEOC is just going to boot it out for being untimely, and that the FCHR, that the commission's not going to come after them because it's already been dismissed by the EEOC and not investigate that charge. And so they could go straight to court, file their lawsuit, and know that nothing's going to happen there by circumvent all the administrative requirements of the Florida Civil Rights Act. Even though the FCRA is supposed to be liberally interpreted, the rule of liberal construction does not mean that this court should adopt an interpretation that leads to absurd results or that defeats the legislative intent. And the Florida Supreme Court has held in Joshua v. City of Gainesville, or they've recognized that the entire statutory scheme of the Florida Civil Rights Act favors the exhaustion of administrative remedies before filing court action. And so the liberal interpretation that the 11th Circuit adopted in that case and that appellant wants this court to adopt ignores the reality or the importance of exhausting administrative remedies.
Well, let's talk about the liberal interpretation of the 11th Circuit, because I don't know if Judge Dabena would characterize it as liberal or a plain textual interpretation. Her opinion suggests that the jurisdiction is divested once a reasonable cause determination has been made. I mean, that's when the lawsuit can be filed, that this particular subsection 5 doesn't speak to complaints filed before reasonable cause determinations have been made. And therefore, the jurisdictional issue is not a problem for those type of complaints.
I would disagree with that reading of that section, Your Honor. That section talks about any action filed under this section, being the FCRA, any action filed under 760.11. A plain reading I would submit is that any action filed under this section, whether or not it's a premature action or one filed after 180 days, divests the commission of jurisdiction. And that makes sense, Your Honor, because if a premature complaint doesn't divest the FCHR of jurisdiction, it could lead to absurd results where, say, for instance, there's a charge of discrimination before the commission. Someone prematurely files a lawsuit, say there's a default judgment entered. Then the commission, within their 180 days, if they still had jurisdiction, they could issue a no-cause determination, in which case that lawsuit never should have occurred. And so you have two bodies with supposed jurisdiction with different results. That just doesn't make sense. So I think that interpretation should be rejected for that reason, in addition to the gaming of the system. If that interpretation were to be adopted, there's nothing to stop a complainant from knowingly having a claim under the FCRA, say, hey, I'm just going to hold on to this for more than 300 days and file it with the EEOC, and then immediately file my lawsuit. And the commission is not going to do anything after that. That circumvents the entire purpose of the procedural requirements within the Act, and I think that is improper.
What was the prejudice to the department in this case by allowing the lawsuit to proceed?
Certainly, Your Honor. If the commission within 180 days were to find no cause, then the appellant's or the complainant's only avenue at that point is to seek an administrative hearing.
Well, but we know, based on the factual record before us, that the FCHR wasn't going to do anything. So based on the record before us, what is the prejudice to the department when we know the FCHR was not going to do anything to this case and 180 days would have elapsed as a matter of law?
With the hindsight, that is what Ms. Wilson testified to, Your Honor. However, we don't know what would have occurred had this lawsuit not been filed. We don't know whether or not someone at the department would have called up the commission and said, hey, what's the status of this complaint? Whether or not they would have called someone at the EEOC and said, hey, we haven't heard anything. We haven't had our opportunity to participate in the conciliation process to provide a position statement. Maybe they would have sent a Form 212 from the EEOC over to the commission. We don't know what would have happened. So the harm that happened to our client in this particular instance was we were denied the opportunity to have the commission issue a no-cause determination within 180 days precisely because the lawsuit was filed and the chain of events that happened did happen. We don't know what would have happened had that not occurred. And so the harm is that we were denied the opportunity to have the commission issue a no-cause determination, which would have eliminated the possibility of a lawsuit and having to defend against the lawsuit. And I would submit that our client having to defend in this case is precisely the harm that has occurred. In addition to the points I've already raised, Your Honor, I believe another reason why the lower court's decision should be affirmed is that the appellant has abandoned or failed to preserve for appeal the argument that the premature filing of her complaint did not divest the commission of jurisdiction. Now, in her initial brief, appellant improperly commingles arguments that she made before Judge Reynolds on a motion for rehearing with arguments that she made before Judge Bean in opposition to the department's motion for summary judgment. Now, key argument that she made before Judge Reynolds but did not make before Judge Bean was that the premature filing of the complaint did not divest the commission of jurisdiction. Now, that argument I would submit is off limits for two reasons. First, it's off limits because the initial brief doesn't address the order denying the motion for rehearing. Now, although the notice of appeal attaches a copy of that order, it's undisputed that the initial brief doesn't raise a single argument that addresses the motion denying the motion for rehearing. So it stands to reason that because the initial brief doesn't address the order denying the motion for rehearing, any argument that was made to the lower court solely in support of that motion has been abandoned. Now, a second reason I think that argument's off limits, Your Honor, is it hasn't been properly preserved for appeal. According to Florida Supreme Court, for an issue to be preserved for appeal, it needs to be presented to the lower court, and the specific legal argument or ground to be argued on appeal must be part of that presentation if it is to be considered preserved, and that's in Hoskins v. State. Now, in this case, Your Honors, Judge Reynolds denied appellant's motion for rehearing. Now, as a result of that, any arguments that were made solely in support of the motion for rehearing were not properly before the lower court when it ruled on the department's motion for summary judgment. And so, because the only order currently before this court is the order denying the motion for summary judgment, The only arguments that are properly before this court are arguments that were considered by Judge Beam when he ruled on the department's motion for summary judgment. And so for that reason, I believe the argument is off limits and should not be considered by this court, Your Honors. I would like to address one point that appellant's counsel made, that he says that plaintiff did everything that was asked of her, but that is not the case. The FCRA has certain procedural requirements, and appellant, because those procedural requirements are published in the Florida statute, she was put on constructive notice of what those requirements were. The only reason she's facing the fatal defect that she is faced with today is not because of anything that the EEOC or the FCHR did. It's solely because she waited to the last minute to file her charge of discrimination, and then she took the affirmative step of prematurely filing her complaint, even though she was put on constructive notice of the fact that the commission needed 180 days to investigate the charge. Unless the court has any questions, I'd ask that the...
I actually have one more question.
Yes, Your
When does the record indicate FCHR got the referral and started work? I mean, in other words, we know that there was some breakdown in communication between the EEOC. The Form 200 or 212 wasn't generated, wasn't sent to FCHR. You know, if you're in plaintiff's shoes, how does she know when the clock starts ticking, the 180 days?
Well, she knows that, Your Honor, because under the work-share agreement, she dual-filed her charge of discrimination with both the EEOC and the FCHR. So at the moment when she dual-filed on September 4th, 2012, the 180-day clock began to tick at that moment. So she was put on constructive notice of, you know, she knew she didn't get a cause determination from the commission, and so she knew she should have waited 180 days before filing her lawsuit, where she only had a single state law claim. Thank you, Your Honors. For all these reasons, we would ask that this court affirm the lower court's decision in all respects.
Garrity?
I'm not sure I had any time left. Thank you.
You have 2 minutes. 2:04.
All right, I'm just going to fill in 5 real quick points, and then I'll be done. We've had some talk about the right to sue letter, and it's saying something about it. These may be federal claims only. That's why I mentioned that I also practice in Georgia. There is no Georgia Civil Rights Agency, so everything in Georgia is done by the EEOC. That right to sue letter is generic across the country. Some states have what we call these Fair Employment Practices Agencies, like the Florida Commission on the Parkway. Some don't. The letter is the same. The right to sue letter is the same whether it's Florida, Georgia, or any other state. That's why, as a law firm, we wouldn't and would never wait more than 90 days to file the lawsuit. We have to. Under Florida's work-share agreement, it's one for all for one. When the EEOC issues that right to sue letter, we're not going to get one from the Florida Commission. We can't wait. Number 2, the Sweeney case, and you had asked a question about that earlier, Judge Ray. If I recall from the briefs correctly, even the 3rd DCA in a later case called Jackson said Sweeney does not mean that we can't abate this. Sweeney did not say what the department represented to the trial judge here. Jackson, the court, 3rd DCA and Jackson is very clear about what Sweeney said and what it didn't. Gaming of the system, point 405. We didn't game anything here. We thought the system would work the way it's supposed to work. We always file with the EEOC. They always pass it to the Florida Commission so the Florida Commission knows it's out there. We had nothing to do with that. There's no gaming going on here at all. It was simply a breakdown when the EEOC didn't pass the ball to its brethren. And Woodham and Joshua, the 2 Florida Supreme Court cases, I'd be the first to acknowledge there are competing principles in those cases. One of the underlying themes in those cases is do what you can to liberally interpret this law in favor of finding remedies. And that's where we think this case goes back to the circuit court. And thank you again. I got 14 seconds left. I did good. Thank you.
Mr. Garrity. Thank you both, counsel. Being that we have no other cases today, we are adjourned until 9 o'clock tomorrow morning.
All rise.